my amendment, my first one here, amendment number 1, and which is simply around ensuring that the bill would be well drafted if my changes. So a number are consequential, whereby if my proposal was accepted, I've tried to ensure that the bill would still be robustly drafted. But the fundamental point in this set of amendments is that I believe if the documents are to be deposited with the body, again, there are very strong and very, I think, very robust views that they should, in fact, all documents should simply be with the Minister until a really appropriate process has been put in place in terms of ensuring that all relevant parties can access them in a way that's appropriate with appropriate regulations. But if these documents, and particularly that section of them which is the database and relevant records, is to be deposited with a body, a more appropriate body would be the Adoption Authority of Ireland. And I say that for a number of reasons. The Adoption Authority of Ireland were the envisaged repository in the 2017 legislation when that had been brought forward. And as I understand it, there was also, and I'm reading this is really important, there was a lot more clarity and detail in that proposed 2017 legislation. And I would note that for all of the other areas of controversy, this was actually not one of the main areas or focuses of controversy on the draft 2017 legislation. There was a lot of detail in terms of how those records would be treated and where they would go. The bill we have before us today ensures simply a very blunt transfer of a database and relevant records to TUSLA with no guarantees as to how they will be treated, where they will be stored, whether they will be kept together in one place, whether, as we know, the argument for it going to TUSLA is that a lot of relevant documents came from TUSLA, will those documents go back into different filing cabinets around the country? If they're meant to be used by TUSLA in the functioning, will we see the huge work which was assembling effectively this body of connected work to paint a picture of the serious concerns and abuses in our mother and baby homes institutions be in effect scattered? In the 2017 legislation, where the Adoption Authority, which again holds one of the largest sets of records, they hold a large number of the legal records. They don't hold all the institutional records, but they hold the legal records in terms of adoptions, including adoptions which were really, in some cases, forced adoptions as well. But they have the records from the Coonass homes. We know the Adoption Authority are in negotiation to have large numbers of other records of adoption transferred to them. They have a key piece of the puzzle, particularly and crucially important for adoptees who are trying to trace their records. Yet the other set of records are coming from TUSLA and that are with the Commission relate to the circumstances that may have surrounded that adoption, legal or indeed questionably legal as it might be. There was a very strong rationale for the Adoption Authority to be selected at the time, but crucially, there was also a lot of provision of how they would do it. The authority should maintain all of the records, that they would maintain them properly, that an index, this is vital, and Minister, there are other amendments which I fully support coming before you today, and I know it was said, when you say you don't know what's in these you don't know what's in these reports, or you don't know what's in this group of documents, we have to know what the documents are so that we can know how is appropriate to treat them. And it was provided for in the 2017 legislation that the Adoption Authority would keep, and this is under part 11.2a of that, an index of the records referred to and a searchable electronic database of the records. We also know that the Minister would have been able to issue guidelines in terms of the appropriate treatment of these records. There was some sense that the records and the documents were going to be transferred to a place where they would be treated properly, and we know that the Adoption Authority took seriously their understanding that if they received these, they would be regarded as a place of deposit and would be required to keep all of the relevant documents to a standard of a place of deposit, that is an archival standard protecting all of the relevant documents, ensuring a clarity around how they are preserved electronically also. And we know that the Adoption Authority, in the years since 2017, had actively pursued the responsibilities and met, for example, with the OPW around appropriate locations for such a repository. They had, for example, visited Germany, as I understand it, to look at comparable storage of very equally sensitive documents in Germany. So it's a serious thing to have these documents transferred to you. And there is nothing, unfortunately, in this bill that tells us how, besides saying what they won't look at, there's nothing that tells us of how they will be preserved, of how they will be kept together, of how we will have an index that is searchable and know what are the documents and what they might be relevant, be they relevant to future regulations around access, be they relevant around future archives, or be they indeed relevant around future tribunal. So again, Minister, this set of amendments simply says that you would replace the references to the agency in the legislation with the authority. I also have other amendments which I'll come to, which is I believe that both the Adoption Authority and TUSLA, as two of the main bodies who will receive subject access requests from individuals personally and directly affected by these issues, should be in a relationship of data controller and data processor where they can cooperate in ensuring that those subject access requests, where one half of the picture might be a legal form that you were adopted and the other half of the picture might be the circumstances under which your mother was signing that paper, that they would be able to piece those two pieces together, for example. These are really fundamental parts of the puzzle. So, Minister, I hope you will consider accepting the amendments in respect of the Adoption Authority. I also have, actually I probably should have separated it out, amendment number 6. I suggest that if you're not going to deposit them with the Adoption Authority and maybe not with TUSLA, that you may wish that instead all of the documents would be deposited with you, Minister. That would allow you to make an appropriate future choice in respect of which body might be best to act as data controller or indeed as preserver and maintainer of these records, with appropriate relationships of access due to, of course, appropriate safeguards attached to the relationship between other bodies, be they tribunal or be they TUSLA on those. So again, Minister, those are the logics behind what I put forward, and I really hope. And I hate to say it, I've spoken largely around the positive reasons that I believe the Adoption Authority was a more appropriate location, or indeed, Minister, rather the reasons you should have preserved your own right to recognise and consider properly what might be the most appropriate public body or bodies. But there is also a concern, not just around the absence of the positive measures which the Adoption Authority had looked to, but around we have had absolutely no information of how TUSLA will act in relation to these documents. That's there is no clarity around how they will be stored, how they will be preserved, how they will be treated. And there is a real concern, unfortunately, of distrust in the way that TUSLA has, in the past, engaged with both survivors of institutional violence and, indeed, with adoptees. The interpretation, frankly, of GDPR by TUSLA has, I think, been very questionable in many cases, not simply in terms of information, but also in terms of tracing and their tracing services. And there's been huge frustrations at a culture, it seems to be, within the treatment of documentation. Now, I hope TUSLA can rebuild its reputation and rebuild its relationships with the very, very many vulnerable persons with whom it works, and indeed their families. But there is a concern and an issue of trust in relation to TUSLA that also needs to be addressed. And again, I believe by selecting the Adoption Authority, Minister, you would have made some gesture of recognition of those very serious concerns which have been